Here is something that thousands of immigrant families get wrong every single day, and the consequences can follow them for years. The public charge rule. Most people have heard the name. Very few people actually understand what it covers. And that gap between the fear and the reality is costing families their health, their nutrition, and their peace of mind over programs that were never going to hurt them in the first place. Welcome back to U.S. Benefits Update. I am Claire Hollister. We exist to cut through exactly this kind of confusion, and today we are giving you the clearest explanation of the public charge rule you are going to find anywhere. Here is the core of it. Under U.S. immigration law, the government can determine that someone is likely to become what is legally called a public charge, meaning primarily dependent on the government for their financial support, and use that determination to deny a green card application or an immigrant visa. According to recent reports, the current administration is treating public charge enforcement as a serious priority, and officials familiar with the matter say that adjudicators have been instructed to look at this issue more carefully than they have in recent years. So yes, this is real, and yes, it matters right now. But here is where most people go completely wrong. The programs that actually count under the public charge rule are narrow. We are talking primarily about Supplemental Security Income, SSI, and Temporary Assistance for Needy Families, TANF. These are direct cash assistance programs, and long-term reliance on them as your main source of income is what the rule is actually concerned about. That is it. That is the core of what triggers a public charge concern. Now here is where things get interesting. Medicaid does not count. SNAP, which most people call food stamps, does not count. CHIP, the Children's Health Insurance Program, does not count. Housing assistance does not count. Emergency medical care does not count. School lunch programs for your kids do not count. And multiple outlets have documented that millions of immigrant families have been terrified to use these programs that pose zero risk to their immigration status, because of a misunderstanding of what the public charge rule actually covers. That fear is real. The harm it causes is real. But in many of these cases, the legal risk simply was not there. And this is where it starts to matter for everyday people in the most direct way possible. A parent going through a green card application who stops accepting SNAP benefits for their family because they heard the public charge rule covers everything. That family is going hungry based on a misunderstanding. A child who does not get enrolled in CHIP because their parents are afraid, that is a real health consequence with no legal basis behind it. According to reports from public health researchers and immigrant advocacy organizations, the chilling effect of public charge fear has been measurable and significant. And the current enforcement environment is intensifying that fear even further. So what should you actually do? If you are in the process of applying for a green card or an immigrant visa, the first and most important step is to speak with a qualified immigration attorney about your specific situation. The public charge analysis looks at the totality of your circumstances: your employment, your health, your family support, your financial assets, and your benefit history, and context matters enormously. It is not a simple checklist. It is a judgment call, and having a legal professional in your corner to present your full picture makes a real difference. What you should not do is panic and stop using programs that are genuinely safe for you to use. Medicaid, SNAP, CHIP, housing assistance, these are available to you, and using them does not damage your immigration case. Refugees, asylees, and certain other protected categories are exempt from the public charge rule entirely, so if you fall into one of those groups, the rule does not apply to you at all. The bottom line is this: the public charge rule is real, and it is being enforced seriously right now. SSI and TANF as primary income sources are the main concern. Most other major benefit programs are not counted. The right response is accurate information and qualified legal advice, not fear-based avoidance of programs your family needs. If you want the full 20-minute breakdown of everything we covered today in complete detail, we have that video on this channel. Go watch it.
And if this short version helped you, hit that thumbs up, share it with someone in your community who needs to hear it, subscribe to U.S. Benefits Update, and turn on your notifications.
I am Claire Hollister. We will see you in the next one.